Okay, well, you're back on the record.
Judge, the defense would renew its motion for directed verdict for all grounds previously stated. The court would allow us to incorporate by reference all previous arguments, make the same motion, submit that the Commonwealth, a reasonable juror could not believe, convict beyond a reasonable doubt any of the charges. In addition, we would add to all the arguments previously made. I don't believe that Commonwealth approved the element of feigning, so I would move to for directed verdict on these charges, all these charges.
Response?
Your Honor, we've given the standard in viewing the evidence like most favorable to Commonwealth. We've incorporated all our prior arguments, and we believe that the count should be directed verdict against, and that they should be, that they've all met the threshold to be a jury issue to determine whether or not the defendant's guilty.
All right. I will deny the motion for directed verdict at this time for the same reasons as previously stated. I do believe when the evidence is viewed in the light most favorable to the Commonwealth that a reasonable juror could convict Mr. Briggs. So I'm denying that motion. Anything else we need to bring up before instructions?
No, Judge.
Okay. Let me go check on these.
Judge, there would be one thing from the Commonwealth, I guess, and I didn't know when you said that in the closing, the Commonwealth objected to opening about the, I guess, history of any defendant on trial in the guilt and innocence phase. There was no evidence that the defendant didn't have a prior record or anything like that that was put into evidence. That we're renewing our motion that this doesn't have anything to do with whether or not he did what he did, and that in reference to closing, my guy has just a marijuana, or my guy doesn't have a serious, that there's no proof of that in trial, and that we also believe that although that's appropriate for penalty, that whether he had a lengthy, long record or no record at all, it's irrelevant to guilt. So we would ask the court to prohibit argument on that.
Well, I'd object, Judge. I'm allowed to argue inferences from the evidence, and the evidence says he had a carry and conceal license weapon,
I think he can say,
which involves record checks and so forth. So I don't plan to say he only had one citation, marijuana or anything like that, but I'm going to certainly point out that he was eligible to have, was reviewed and got a carry and concealed license, and was issued a certificate by the Commonwealth of Kentucky.
Okay.
All of which is appropriate.
I will allow that, but I am going to grant the motion in terms of prohibiting any. In opening, you did reference, he has no record other than a POM. I'm going to prohibit you from saying that during closing because there was no evidence of that. But certainly, you can bring up the fact that he qualified for a concealed carry license. Anything else before I go grab? I'm going to check on these.
No, Judge.
Okay. aching a little bit. I'm gonna take us off the record. Man. I have made one change, which was that on page 10. It's not a substantive edit. But changing the number, it was misnumbered. All right, regarding the instructions, Mr. Eggert, you had some objections?
Yes, absolutely, Judge. There's no grounds for a provocation instruction. And the case Barker versus Commonwealth, okay, where in fact, in that case, Barker cut the tires of the person who ended up being killed. And they said, well, no, they couldn't possibly get a provocation instruction. Barker was seeking to avoid a direct confrontation with the victim. The provocation qualification instruction, and this is in Barker, should be reserved for situations where the Commonwealth can show the defendant intended to kill the victim all along. And there's simply no proof of that in this case. He goes into Olive Garden. Yes, he's armed, but he's permitted to be armed. He's lawfully armed. And where the defendant can show the defendant killed the victim all along and baited the victim to use force first. In fact, he never baited Jose Munoz at all. I don't know that he ever talked to Jose Munoz. Remember, Jose Munoz can't speak English and understood, they said, almost nothing. So he didn't bait Jose Munoz. There's no evidence that he went in there with the intent to kill him all along. And there's no evidence that he baited him. It's totally contrary to Barker. And in addition, Judge, there's all kinds of evidence that my client said, stay away, don't come near, back up, don't come near. In fact, he even said that to the Flores. Come near me and you'll see what happens. In other words, don't come near me. So everything part of that instruction is unsupported by the proof and contrary to the case law and contrary to Barker. And I've got Barker right here.
What is that site?
The site is 477 Southwest 3rd, 583, 2015. And it's the Kentucky Supreme Court case.
Response?
Your Honor, in terms of the provocation, the first part of that is that the defendant provoked with the attempt to use physical force against him. I think that, as this trial came out, that you realize this thing happened in kind of an order, and certainly the jury could believe that because he did, and the statements he made in witnesses saying he antagonized it, he kept provoking it, it kept going on, and saying things to his fiance at the time that he was, I think the last one was that I'll cause physical harm to the woman he's with. Then there's the intention of causing death or serious physical injury, and that clearly the first one exists, that there's provocation out there, certainly with words, and that's sufficient. And then we think it's a jury question on the intent to cause the serious physical injury. We know he had a gun. We know he knew he was the only one with a gun there. We knew there's no testimony that anyone else had a gun there. And although I understand that the defense counsel's argument, I think that serious physical injury portion is something that the jury could consider based on the facts and conclude that, Your Honor.
Judge Barker, the inferential beliefs required for a jury to get from a defendant intending to piss off the victim to intending to kill the victim are more than we can allow. And I can give the court right here, and I've yellow marked the specific statements by the Kentucky Supreme Court. He didn't bait Munoz. Munoz doesn't understand English. There's no evidence that he intended to kill him all along, or that he intended to have him go over there, and all their evidence, including their own thing, as he said, kept saying back up. So provocation just does not apply in this case.
Well, again, the Commonwealth, this this was a fluid event that evolved. What was said initially to Jose Rodriguez and to the females and how it ended were two different things and how it began. So, Your Honor, I think words are certainly sufficient. This wasn't an incident that happened days before or hours before. This is right there, and this is an escalation, and he certainly was provoking Jose Munoz there. I think, what was the direct quote for the wife? I'll smack the shit out of you. I mean, you know, that's classic provocation, and
I'm gonna keep the instruction the way it is. I mean, I've just reviewed the Barker case, and one of these highlighted portions I think really kind of makes the point as well. But the Barker case, I do think is distinguishable because, as the Supreme Court notes in that case, he was slashing tires in the dark of night trying to hide and was confronted by the victim. In this case, there has been evidence that Mr. Briggs was initiated this encounter and really kept it going and instigating. I don't think that there's a requirement that the victim speak English. I don't think you need to speak the language to understand what aggressive is when it's coming at you. So I think that the jury, I'm going to keep the instruction. I think the jury should consider that.
Well, I'd object, Judge, and I think that's any time you use words, then they can come up with this provocation instruction. It's pretty frightening.
Well, the testimony was also that he chest bumped him and continued to threaten the women, that he then, when the victim walked up, Mr. Briggs chest bumped him, turned around and grabbed his gun and shot him. I think there's enough for a provocation instruction, but your objection is noted for the record, so what's your next one?
Then I'd like that to be added, Judge, because at least that, I've got it right here, at least that states in fact what the law is, that you have to intend to do it all along. Intent does not apply except when the Commonwealth proves that he intended to kill Holden and Lewis all along and baited the victim. That's direct words from the Barker and the Kentucky Supreme Court case.
Okay, then what definition will we give them for all along?
Pardon me?
What definition will we give them for all along? 'Cause certainly
Well, all along,
intent
I'm
can be
just
formed at any
taking,
time.
I'm just taking, I guess, from when the encounter with the group began, but I'm just taking literally the words of the Kentucky Supreme Court, and where they say this instruction shouldn't be given, and it should be reserved for a situation where they can show the defendant to kill the victim all along and baited the victim to use force first.
Okay. I'm going to deny the motion to supplement it. I think the Cooper's instructions are sufficient. I think it could confuse the jury if we say all along, because they might misunderstand that to mean when he walked into the restaurant or when the encounter first began. I mean, intent can be formed at any point. So I'm going to deny the motion to supplement.
Then if you could mark that denied, Judge. And again, that additional instruction came exactly, precisely from the case itself.
Which is distinguishable, but yes. All right.
Well,
Your next objection.
the case may be distinguishable, but they're talking about the, yeah.
All right, Mr. Eggert.
Judge, we'd object to the initial aggressor instruction. Again, under the proof, you only get the initial aggressor if they show from the evidence that the defendant was the initial aggressor in the use of physical force. The evidence is overwhelming in this case from their proof, is that Mr. Munoz walked over the defendant. As the defendant tried to stand up, he pushed him back down. The initial use of physical force, in fact, he shoved him back down hard enough that he would have fallen. The initial uses of physical force, according to literally Hack, O'Brien, Moore, I think even Stephen Bell, all say that Mr. Munoz was the initiated that first contact. And I think even Linda Flores ended up saying that. There's just not sufficient evidence that in fact the defendant first used force. And if he's not the first one to use force, then he cannot be the initial aggressor. Second of all, Judge, he didn't intend to cause death or serious physical injury. His initial force is nothing. He's just trying to stand up, and he's pushed down. In all the evidence, my client keeps saying, even to the end, Mr. Young heard, the last thing Mr. Young heard was back up, back up. And that also makes 1 and 2 and also B apply. B, he withdrew. I don't think he was in an encounter at all, but assuming he was, when he says back up, don't come near me, he's communicated his intent not to be in this, and Munoz nevertheless continued and did use physical force against him. So there's no evidence that my client was the initial aggressor, and we'd object to this instruction.
Okay, I'm gonna, really just in the interest of time here, I'm gonna keep that instruction. I think the instruction is clear that obviously if he did not intend to cause death or serious physical injury, that the jury would not find provocation, but there has been evidence that he stood up and chest bumped Mr. Munoz, that he was the initial aggressor, so I'm gonna leave the instruction. But your objection is noted.
All right, Judge, we would object on the right to remain silent under number 3. It says she did not. The fact that the defendant did not testify in this case cannot be used as inference of guilt, and I think guilt and should say and shall not prejudice him in any way, because it shouldn't prejudice him in any way.
Okay. Any response? Any objection to changing that? I'll change it. I think that's straight out of Cooper's, but I'll change it to shall. Okay.
Right, again, Judge, we object to the self-protection and provocation instructions. Finally, we'd object to...
You object to self-protection?
No, the initial
exceptions.
aggressor. That
Okay.
part of it, the initial aggressor, and the provocation instructions. We would also, Judge, object to the remainder of instructions with murder, wanton endangerment first, and wanton endangerment second, for all grounds stated in the directed verdict motions. We would reiterate those arguments and incorporate those arguments by reference, that there's insufficient proof that in this case, to support those for all reasons stated. The defendant was acting in self-protection. I'd also, and that there was nobody else was endangered. The shot was from 2 inches, and the shot was downward. No evidence that anyone else could have been or would have been in danger. Finally, I'd object because of the failure to give the instruction regarding defense of another regarding Brittany Briggs.
You're asking for a defense, that's not in your proposed instructions, but you're
Yeah,
asking.
we sent it to you.
I have the instructions with the wanton endangerment added, wanton endangerment second. What number is defense of another in your proposed?
No, let me look. Miss Lister sent it over the weekend. Here it is, instruction 2A.
2A.
Right here, so.
Instruction 2's burden of proof.
Here.
I didn't receive that. Okay.
I'm sorry, we did submit it. If the court didn't get it, we did. In fact, we submitted it over.
I didn't get it. What number was it?
Okay. Maybe it fell through the cracks or something, it didn't come through. Okay, so there's a request for protection of another instruction.
I never got that, so if whatever we're referring to, if I could get a
Do
copy
you want to come
of
up and
that,
take a look at it?
I'd be happy to look at it.
You might want to make sure this gets e-filed.
Pardon me?
You might want to make sure that gets e-filed as well,
Okay.
just to make sure it's on the record.
Okay, thank you. I'm sorry, but we did do it in that.
I don't know.
No, I mean, Miss Lister did it.
I believe it was written, I just don't know where it went. Because I got,
I never got it.
Pardon me? I let it
there was an email from, I don't think you need to call her to make sure, I would just make sure it gets e-filed so that
Okay.
it's in the record.
All right. I think we would object, but candidly, having not got that, I didn't do some research on it. If I get a copy of it, I can call and maybe put a more legal argument, but the Commonwealth's initial would be that they don't believe there was any evidence that would support that instruction involving the female sitting near the defendant.
Can you point to me some evidence that was submitted at trial so the proposed instruction is that the defendant believed Munoz was about to use physical force upon Miss Briggs.
Well-
And then also that Miss Briggs herself believed that there was about to be physical force used upon her and it was necessary. I don't recall any testimony about any beliefs by Miss Briggs whatsoever.
No, but I think we would argue inferentially, she was, at least for most of the encounter, right next to him, according to their proof. Everything, keep saying she was right next, she was in the corner, she was sitting next to him. She would have observed all that. She would have observed Munoz come over, she would have observed that and the fist cocked, and she would observe, even if she was leaving at that point, running out, she would have observed, we would submit the punch. So based on all that, I think, a jury could believe that he was defending not just himself, but the person who'd been sitting next to him throughout, through most of the encounter. And so we believe we're entitled to that instruction, and that's what we would ask.
Your Honor, we don't, my brain is what happens when we can have. Commonwealth didn't hear any evidence that would support giving this instruction. The Commonwealth thinks the defendant's on words where I pulled out my gun and then he pulled this back, if you want to believe that. There was no testimony in the trial that indicated that she was afraid of anything or fearful, and nor was it called her, nor did her statement, that didn't indicate any of that. So the Commonwealth doesn't believe there's any factual support for giving that instruction, and based on its recollection of the proof as a whole in this case.
The only thing I recall regarding anything, any feelings or thoughts or statements by Mrs. Briggs, was in the defendant's statement where he told Detective Chrisman, his wife said, "Why'd you do that?" right after the shooting. That's the only thing I have regarding anything she may have felt or thought. I'm gonna deny the request for the instruction. I just don't think there's been any evidence whatsoever that either the defendant or Miss Briggs thought she was in danger. There was an entire statement played by the defendant explaining why he did what he did, that he thought he was going to be mauled, that he thought he was in danger. Never once did he mention that he thought his wife was in danger. His wife did not say she thought she was in danger, so I'm gonna deny the request for that instruction.
Thank you, Judge. Judge, could we approach the bench, please?
You may.
Judge,
This is-
his wife had in either side called her would have invoked the special privilege, as would mine, as would my client. So I don't think either side can comment on the fact that she didn't testify. There's a privilege like the Fifth Amendment. All right.
Any response?
I don't think we were, but if you want to invoke the privilege, he has to sit here and invoke it. It's not like we pretend it got invoked. I don't think we're going to say anything, but what you said is not correct under the law, but we're not going to talk about it either way. So
They're not going to talk about it. That
Okay,
solves the issue.
great. I think it's something like 650 pages that are getting printed, so it's probably going to be another 15 minutes. I'm going to tell Hutch to let the jury know.
Okay.
Hopefully just 15 minutes.
Okay, the second thing, judges, if you recall, and I can do it while the jury is out, that'd probably be a good time to do it, but I still got to do those two avowals.
I've got motion hour too, so but I'm sure we
I
can
can
do
do
it
it
today.
somewhere, yeah.
Okay.
And Judge, the third thing is this, okay? I don't know what happened exactly, but Taylor, who's been assisting us, Lisa Drew's granddaughter, she's present. Her,
Whose granddaughter?
Lisa Reed,
Oh,
she's
okay, yes.
her car was broken into and stolen from the garage, and they suspect your client's family. Okay, hold on. So
Okay.
there's apparently video, and I told them before we do anything, they may do anything, get the video, review the video, show it to police. Okay, but that I wanted to tell them.
I would
about.
show it to the police, because if someone committed a crime, they would have to do something about it.
Well, yeah, they're trying to get the video. Yes.
That'd be a good idea, I think. Nothing makes you mad when
Okay.
someone busting your car.
Well, yeah, they'd had problems with them. Just that's what I'm saying.
Lisa's granddaughter? Okay.
Yeah,
All
well,
right. Okay. I'm going to take us off the record. Hutch, could you let the jury know it's probably going to be another 15 minutes because we've got a lot of pages printing. So if they need to use the restroom.
Judge, while we're waiting, I'll just object for the record for the failure to give the defense another instruction for reasons already stated. Thank you.
All right, we got everybody? Let's bring them in.
All rise for the jury.
All jurors present, Your Honor.
All right, please be seated, everyone. Thank you. Good morning. I hope you all had a good weekend. Were there any issues with the admonition over the weekend? All right, wonderful. In a moment, I'm going to instruct you on the law of the case before we get to closing arguments. After I've instructed you, the attorneys will give closing arguments. The defense will go first, followed by the prosecution. Closing arguments are not evidence, but are counsel's chance to sum up the evidence and recommend how they believe you should find. After closings, you will retire to the jury room, which is through that door over there, where you should first select a foreperson to preside over your deliberations. Should you have a question, please write it out on a piece of paper and advise my deputy sheriff, who will be posted outside your door at all times. Also, when you reach a verdict, please advise my deputy sheriff and we will reconvene in the courtroom. If you have a cell phone, please turn it off. During deliberations, you may only converse with each other. If you use a telephone, if you need to use your phone, please advise my deputy sheriff and he will allow you to do so. All right, now you each should have a copy of the jury instructions that were in your chair. In the case of the Commonwealth of Kentucky versus Devonen Briggs, under the evidence presented to you in this case, you may find the defendant not guilty, or you may find him guilty of the following offenses: murder as set out under instruction number 8, second-degree manslaughter as set out under instruction number 9, reckless homicide as set out under instruction number 10, first-degree wanton endangerment as set out under instruction number 11, second-degree wanton endangerment as set out under instruction number 12, first-degree wanton endangerment as set out under instruction number 13, second-degree wanton endangerment as set out under instruction number 14, first-degree wanton endangerment as set out under instruction number 15, second-degree wanton endangerment as set out under instruction number 16, first-degree wanton endangerment as set out under instruction number 17, second-degree wanton endangerment as set out under instruction number 18, first-degree wanton endangerment as set out under instruction number 19, second-degree wanton endangerment as set out under instruction number 20, first-degree wanton endangerment as set out under instruction number 21, second-degree wanton endangerment as set out under instruction number 22, first-degree wanton endangerment as set out under instruction number 23, second-degree wanton endangerment as set out under instruction number 24. Please proceed to instruction number 1. Instruction number 1, presumption of innocence. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Please proceed to instruction number 2. Instruction number 2, burden of proof. The Commonwealth has the burden of proving every element of each charge beyond a reasonable doubt. If there is a reasonable doubt as to the defendant's guilt of an offense, then he shall be found not guilty of that offense. Please proceed to instruction number 3. Instruction number 3, right to remain silent. A defendant is not compelled to testify, and the fact that the defendant did not testify in this case cannot be used as an inference of guilt and shall not prejudice him in any way. Please proceed to instruction number 4. Instruction number 4, unanimous verdict. The verdict of the jury must be unanimous, finding the defendant guilty or not guilty, and it must be signed by one of you as foreperson. You shall use the forms provided at the end of these instructions in writing your verdict. Please proceed to instruction number 5. Instruction number 5, definitions. Intentionally. A person acts intentionally with respect to a result or to conduct when his conscious objective is to cause that result or to engage in that conduct. Wantonly. A person acts wantonly with respect to a result or to a circumstance when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The result must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Recklessly. A person acts recklessly with respect to a result or to a circumstance when he fails to perceive a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such nature and degree that failure to perceive it constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious and prolonged disfigurement, prolonged impairment of health, or prolonged loss or impairment of the function of any bodily organ. Physical force. Force used upon or directed toward the body of another person and includes confinement. Deadly physical force. Force which is used for the purpose of causing death or serious physical injury, or which the defendant knows to create a substantial risk of causing death or serious physical injury. Please proceed to instruction number 6. Instruction number 6, self-protection. 1. If at the time an individual, including the defendant, uses physical force upon another person, he believes that that person was then and there about to use physical force upon him, he is privileged to use such physical force against that person as he believes to be necessary in order to protect himself against it, including the right to use deadly physical force, but only if he believed deadly physical force to be necessary to protect himself from death or serious physical injury. 2. A person who is not engaged in unlawful activity and who is attacked in a place where he has a right to be, has no duty to retreat, and has the right to stand his ground and meet force with force, including deadly force, if he reasonably believes it is necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a felony involving the use of force. Please proceed to instruction number 7. Instruction number 7, exceptions to self-protection, initial aggressor provocation. 1. If you believe from the evidence beyond reasonable doubt that the defendant was the initial aggressor in the use of physical force, the defense of self-protection is not available to him unless A, subsection 1, he did not initially intend to cause death or serious physical injury to Jose Munoz, and his initial physical force was not such that he thereby created and knew he was creating a substantial risk of death or serious physical injury to Jose Munoz, and 2, the force returned or threatened by Jose Munoz was such that the defendant believed himself to be in imminent danger of death or serious physical injury. Or B, subsection 1, the defendant withdrew from the initial encounter and effectively communicated to Jose Munoz his intent to do so, and subsection 2, Jose Munoz nevertheless continued or threatened the use of physical force against him. 2. If you believe from the evidence beyond reasonable doubt that the defendant provoked Jose Munoz to use or attempt to use physical force upon him, and that he did so with the intention of causing death or serious physical injury to Jose Munoz, then the defense of self-protection is not available to him unless you further believe from the evidence as follows. A, the defendant withdrew from the initial encounter and effectively communicated to Jose Munoz his intent to do so, and B, Jose Munoz nevertheless continued or threatened the use of unlawful physical force against him. Please proceed to instruction number 8. Instruction number 8, murder. You will find the defendant, Devonen Briggs, not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in Jefferson County, on or about February 23, 2019, he killed Jose Munoz by shooting him, and 2, that in so doing he A, caused the death of Jose Munoz intentionally, or B, he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Jose Munoz under circumstances manifesting an extreme indifference to human life, and 3, that he was not privileged to act in self-protection. If you find the defendant, Devonen Briggs, not guilty under this instruction, you shall proceed to instruction number 9. If you find the defendant, Devonen Briggs, guilty under this instruction, you shall say so by your verdict and no more, and proceed to instruction number 11. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 1. Instruction number 9, second-degree manslaughter. You will find the defendant, Devonen Briggs, not guilty under this instruction unless you believe from the evidence beyond reasonable doubt all of the following. 1, that in Jefferson County, on or about February 23, 2019, he killed Jose Munoz by shooting him. And 2, that in so doing, he was acting wantonly or as described in paragraph 3B of this instruction, and that in so doing, he was not privileged to act in self-protection. Subsection A, he was not privileged to act in self-protection, or subsection B, though otherwise privileged to act in self-protection, the defendant was mistaken in his belief that it was necessary to use physical force against Jose Munoz in self-protection, or in his belief in the degree of force necessary to protect himself, and that when he killed Jose Munoz, he was aware of and consciously disregarded a substantial and unjustifiable risk that he was mistaken in that belief, and that his disregard of that risk constituted a gross deviation from the standard of care that a reasonable person would have observed in the same situation. If you find the defendant, Devonen Briggs, not guilty under this instruction, you shall proceed to instruction number 10. If you find the defendant, Devonen Briggs, guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 11. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 2. Instruction number 10, reckless homicide. You will find the defendant, Devonen Briggs, not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. That in Jefferson County, on or about February 23, 2019, he killed Jose Munoz by shooting him, and 2, that in so doing he was acting recklessly or as described in paragraph 3B of this instruction, and 3, that in so doing, A, he was not privileged to act in self-protection, or B, though otherwise privileged to act in self-protection, the defendant was mistaken in his belief that it was necessary to use physical force against Jose Munoz in self-protection, or in his belief in the degree of force necessary to protect himself, and that when he killed Jose Munoz, he failed to perceive a substantial and unjustifiable risk, that he was mistaken in that belief, and that his failure to perceive that risk constituted a gross deviation from the standard of care that a reasonable person would have observed in the same situation. If you find the defendant, Devonen Briggs, not guilty under this instruction, you shall proceed to instruction number 11. If you find the defendant, Devonen Briggs, guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 11. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 3. Instruction number 11, first-degree wanton endangerment. You will find the defendant, Devonen Briggs, not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of death or serious physical injury to Linda Flores. 3, that under the circumstances such conduct manifested extreme indifference to the value of human life. If you find the defendant, Devonen Briggs, not guilty under this instruction, you shall proceed to instruction number 12. If you find the defendant, Devonen Briggs, guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 13. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 4. Instruction number 12, second-degree wanton endangerment. If you do not find the defendant, Devonen Briggs, guilty under instruction number 11, you will find him not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of physical injury to Linda Flores. If you find the defendant, Devonen Briggs, not guilty under this instruction, you shall proceed to instruction number 13. If you find the defendant, Devonen Briggs, guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 13. Please indicate your verdict using verdict form number 5. Instruction number 13, first-degree wanton endangerment. You will find the defendant, Devonen Briggs, not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of death or serious physical injury to Perla Flores. 3, that under the circumstances such conduct manifested extreme indifference to the value of human life. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 14. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 15. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 6. Instruction number 14, second-degree wanton endangerment. If you do not find the defendant Devonen Briggs guilty under instruction number 13, you will find him not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of physical injury to Perla Flores. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 15. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 15. Please indicate your verdict using verdict form number 7. Instruction number 15, first-degree wanton endangerment. You will find the defendant Devonen Briggs not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of death or serious physical injury to Jose Rodriguez. 3, that under the circumstances, such conduct manifested extreme indifference to the value of human life. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 16. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 17. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 8. Instruction number 16. If you do not find the defendant Devonen Briggs guilty under instruction number 15, you will find him not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of physical injury to Jose Rodriguez. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 17. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 17. Please indicate your verdict using verdict form number 9. Instruction number 17, first-degree wanton endangerment. You will find the defendant Devonen Briggs not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of death or serious physical injury to MRF, Perla Flores' 4-year-old daughter. 3, that under the circumstances such conduct manifested extreme indifference to the value of human life. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 18. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 19. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 10. Instruction number 18, second-degree wanton endangerment. If you do not find the defendant Devonen Briggs guilty under instruction number 17, you will find him not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of physical injury to MRF, Perla Flores' 4-year-old daughter. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 19. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 19. Please indicate your verdict using verdict form number 11. Instruction number 19, first-degree wanton endangerment. You will find the defendant Devonen Briggs not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of death or serious physical injury to ERF, Perla Flores' 4-month-old daughter. 3, that under the circumstances, such conduct manifested extreme indifference to the value of human life. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 20. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 21. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 12. Instruction number 20, second-degree wanton endangerment. If you do not find the defendant Devonen Briggs guilty under instruction number 11, you will find him not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of physical injury to ERF, Perla Flores' 4-month-old daughter. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 21. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 21. Please indicate your verdict using verdict form number 13. Instruction number 21, first-degree wanton endangerment. You will find the defendant Devonen Briggs not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of death or serious physical injury to BSF, Linda Flores' 4-year-old son. 3, that under the circumstances such conduct manifested extreme indifference to the value of human life. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 22. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 23. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 14. Instruction number 22, second-degree wanton endangerment. If you do not find the defendant Devonen Briggs guilty under instruction number 21, you will find him not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of physical injury to BSF, Linda Flores' 4-year-old son. You will find the defendant Devonen Briggs not guilty under this. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 23. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and you shall proceed to instruction number 23. Please indicate your verdict using verdict form number 15. Instruction number 23, first-degree wanton endangerment. You will find the defendant Devonen Briggs not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of death or serious physical injury to CSF, Linda Flores' 7-year-old son. 3, that under the circumstances such conduct manifested extreme indifference to the value of human life. If you find the defendant Devonen Briggs not guilty under this instruction, you shall proceed to instruction number 24. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and your deliberations are over. There will be a further proceeding at which you will determine his punishment. Please indicate your verdict using verdict form number 16. Instruction number 24. If you do not find the defendant Devonen Briggs guilty under instruction number 23, you will find him not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. 1, that in this county on or about February 23, 2019, he discharged his firearm. 2, that he thereby wantonly created a substantial danger of physical injury to CSF, Linda Flores' 7-year-old son. If you find the defendant Devonen Briggs not guilty under this instruction, your deliberations are over. If you find the defendant Devonen Briggs guilty under this instruction, you shall say so by your verdict and no more, and your deliberations are over. Please indicate your verdict using verdict form number 17. And there's a spot for my signature. This is the original set of instructions which is going to go back with you to deliberate, and this will be the set that you will sign. Verdict form number 1, murder. We, the jury, find Devonen Briggs not guilty of murder as set out in instruction number 8. We, the jury, find Devonen Briggs guilty of murder as set out in instruction number 8. Verdict form number 2, second-degree manslaughter. We, the jury, find Devonen Briggs not guilty of second-degree manslaughter as set out in instruction number 9. We, the jury, find Devonen Briggs guilty of second-degree manslaughter as set out in instruction number 9. Verdict form 3, reckless homicide. We, the jury, find Devonen Briggs not guilty of reckless homicide as set out in instruction number 10. We, the jury, find Devonen Briggs guilty of reckless homicide as set out in instruction number 10. Verdict form number 4, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 11. We, the jury, find Devonen Briggs guilty of first-degree wanton endangerment as set out in instruction number 11. Verdict form number 5, second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 12. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 12. Verdict form number 6, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 13. We, the jury, find Devonen Briggs guilty of first-degree wanton endangerment as set out in instruction number 13. Verdict form number 7, second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 14. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 14. Verdict form number 8, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 15. We, the jury, find Devonen Briggs guilty of first-degree wanton endangerment as set out in instruction number 15. Verdict form number 9, second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 16. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 16. Verdict form number 10, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 17. We, the jury, find Devonen Briggs guilty of first-degree wanton endangerment as set out in instruction number 17. Verdict form number 11, second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 18. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 18. Verdict form number 12, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 19. We, the jury, find Devonen Briggs guilty of first-degree wanton endangerment as set out in instruction number 19. Verdict form number 13, second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 20. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 20. Verdict form number 14, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 21. We, the jury, find Devonen Briggs guilty of first-degree wanton endangerment as set out in instruction number 21. Verdict form number 15, second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 22. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 22. Verdict form number 16, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 23. We, the jury, find Devonen Briggs guilty of first-degree wanton endangerment as set out in instruction number 23. Verdict form number 17, second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 24. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 24. All right, and with that, we will proceed with closing arguments. Mr. Eggert?
Thank you, Your Honor. Your Honor, counsel, detective, good morning, ladies and gentlemen of the jury. Good morning. I'd like to begin by thanking each of you for your patience and attention. I know these bench conferences are painful. Your patience and attention are greatly appreciated. Second, I'd like to begin by looking at the instructions. Instruction number one of the most important instructions of all. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he's guilty, you shall find him not guilty. In our country, if there is reasonable doubt, it doesn't say may find him not guilty. It doesn't say should find him not guilty. It doesn't say might find him not guilty. If there is a reasonable doubt in this country, the verdict is not guilty. That's the way it's been for 200 years. That's the way it is today. Hopefully that's the way it'll be for another 200 years. If you believe there's reasonable doubt, and in this case they have to prove beyond a reasonable doubt that the defendant was not acting in self-defense, if you have a reasonable doubt, it is your sworn and solemn duty as jurors to find this defendant not guilty. All right, let's begin. And what I'd like to do right now, with reasonable doubt as our framework, what I'd like to do is look at what the Commonwealth said to you happened in this case. Look at what they said they were going to prove, and let's see if they did prove it. And we submit they haven't proven one single thing that they told you happened. Here was the Commonwealth scenario when this case began. They said that Devonen Briggs walked into that restaurant. Talon Churn, he was an a-hole. He was hostile, okay? When a child stepped on his shoes, he stared at Perla Flores. After that, he pushed the child so hard, the child fell to the ground. When people tried to play peacemaker, Jose Rodriguez, he wouldn't play a peacemaker. He then began to make comments and so forth and so on. At some point, they couldn't calm him down. And so he was so upset that he got off the bench. If this is the bench they told you, he got off the bench. He then walked over, is what they told you. He walked over to Mr. Munoz and chest bumped Munoz. Munoz was just standing there. My client was sitting in a corner. Munoz was just standing there. He chest bumped him. And after he chest bumped him, he shot him for no reason. That was their scenario, and every bit of it was wrong. Let's start right in the beginning with his statement that he was angry when he came in. You remember Talon Churn? She said he was an a-hole in a hostile environment. You remember Miss Churn? She gave 3 different statements to police. She kept adding to her story. She kept adding and adding to it, become more and more against this defendant. She talked to the victim's family first. Then she talked to police. She talked to them 3 times. Each time the story changed. Each time the story got worse. Each time the story was more and more against this defendant. Let's see. When Ramon McGee talks to her, Mr. McGee and I met each other in 1994. We have tried multiple cases together. Let's listen to what Mr. McGee asked her when she came in and was coming in saying, well, he was angry, he was upset. When Devonen Briggs came into the
earlier,
restaurant.
ma'am, you testified that when Mr. Briggs came in, he was what you described as hostile. You recall that? All right. When Mr. Briggs came in, did he speak to you?
He didn't speak to anybody.
Did he speak to the manager?
He didn't speak to anybody.
None of the other patrons?
He
Right.
didn't speak to anybody.
All right.
Everybody asked him
Right.
how he was. He said 2, and that was it.
Right. He didn't argue with anybody, didn't fight with anybody when he came in, correct? None of those things. He was just waiting on his wife to be seated, correct? And he didn't speak with you based on your testimony, correct? But you're describing it as hostile when he walked in?
I said an asshole.
No, but you said it was hostile.
Okay.
Right. But he
I
hasn't
said it was a
spoken.
hostile environment and he was an asshole, was my exact words.
Where did this come from? The man comes in with his wife. Taylor Churn doesn't even talk with him, doesn't even interact with him. You saw her in the witness stand. There was an outburst. She had to be calmed down. We had to take a recess. All that stuff about he came in upset is a lie. He came in with his wife to eat. That's what he did. She didn't talk to him. She didn't interact. She did nothing. In her 3 statements to police, it just gets worse and worse. And then when she gets on the witness stand, she just made that up. My client did nothing but come in there, sit down, and look at his phone because he was going to eat with Brittany. Second, if we want to talk about who might have gotten upset that night, who came in upset, remember Perla? Perla said, what did she say about they were at the Red Lobster? She didn't like the wait. What did she say? Screw Red Lobster. She said she only went to Olive Garden because she didn't want to be a bee. And when she came in there, let's listen.
Did you want to go to Olive Garden?
I did not want to go to Olive Garden.
Okay. Did you all end up going there anyway?
Yes, because I didn't want to seem like a bitch.
All right.
So who's angry when they walk in? Is it the man who's walking in with his wife and sits down on the bench before they ever got there? Is he an a-hole when he's not even talking to Miss Churn? Is he in a hostile? No, he's sitting there next to Brittany. And when that group comes in, Perla was the one who was angry, not the other way around. Next thing that happened. What's the next thing that they say happened? Perla said, well, nephew stepped on his shoes and he gave a hard stare. What are they talking about? A hard stare. But what are they talking about? There was no evidence. No one talked about a stare. Jose Rodriguez didn't. Even Linda didn't. If the way Perla was, if someone stared, you'd think she'd have mentioned it to Jose Rodriguez or to Linda. Nobody mentioned anything because there was no stare. That's another thing that's made up. You got to understand, for 4 years, there's been press, there's been media, there's been innuendo about this guy, and most of these facts have been wrong. All right, there was no stare. It's made up, like the hostile environment and the a-hole. What happens next? What does she say happens next? At some point, she says, at some point, the daughter is pushed by the defendant. The daughter is pushed, and pushed so hard that Taylor Churn initially said fell to the ground in one of her multiple stories. And Perla said she would have fallen to the ground. That's how hard the push was. Would have fallen to the ground. Except that Perla happened to be there, right next to the defendant, caught the child. Otherwise, the child would have fallen. Once again, ladies and gentlemen, once again, that is not the truth. Let's look. Even Miss Churn, in her initial statement to police, admitted that all he did was move the child over to the mom. That was her first statement before. And remember, she talked to the victim's family before she talked to police. But even after she talked to the victim's family, all he did was move the child over to the mom. He didn't push the child. The child didn't almost fall. None of that happened. None of it happened in a bit. And Devonen Briggs was telling the truth when he talked to police. He gave the accurate story. He gave the truthful story. He said, I just moved him over. That's all he did. That's what he said he did. And even Miss Churn, he moved the child over to the mom.
And the question you were asked, did you see him move somebody or push somebody? And your answer was, the baby. I did see him move her over to the mom. Next question, Officer Miller, did he hurt the baby? Your answer was, I didn't. The baby didn't cry or anything. Correct?
He just moved the child over because he didn't like the child climbing up on him, because that would make anyone, apprehensive, and you don't want a stranger's child. That's all he did. Now look at what Devonen Briggs said. The same thing. He didn't push a child.
The little girl, which one first bumped into you? Was it the little boy?
No, I don't think the boy bumped into
The little
It was just a girl.
The little girl, okay. Okay, and she was she trying to sit down?
Well, she wasn't next to me at first.
Okay.
So I'm not sure what she was at. Like, and, like, I'm not sure what the kid was doing. I just know she was stepping on me. I didn't say anything. And I even noticed that one of the guys, he had seen him because he seen me walk off the street. And she did it again. I did the same thing. And then she did it again and tried to prop up on me. And that's when, kind of, no offense, but like.
Okay, just pushed her a
Yeah,
little
just slightly.
bit. Okay.
And then.
And was she sitting on the bench or was she standing?
No, she was standing.
She was
like,
standing
trying
in
to
between.
get up on me.
Okay, gotcha. Okay. So you gently, kind of pushed her up.
That's what he did. And that's what Churn admitted he did. And that's all he did. When the child was climbing up on him, he just went like that, moved to the mother. That's why the mother was there. There was no hard push. There wasn't a fall. There wasn't a fall to the floor. None of that was true. None of it. He said it right from the beginning, and then Miss Churn even admitted it when she first talked to police. And Miss Churn, if any witness in the world was against as she was, she admitted he just moved the child to his mother. What happens next? What did they say happens next? Well, in their scenario next, what happens is that Perla goes and she says to the defendant, "Don't touch my child." She's not yelling, she says, not yelling at all. She just says, "Don't touch my child. If you have a problem, talk to me." She was yelling. She was screaming. Let's not underestimate how much it would take, how someone might get apprehensive or free if someone's screaming at you. Let's see. She wasn't just talking. She was screaming. This is Mr. Bell. He is in the Bianca room. He is 15 to 17 feet away. It's a super crowded restaurant. Remember, people are waiting. There's buzz. There's noise all the time. Yet, in another room, 15 to 17 feet away, he hears the screaming by Perla. Let's hear.
People being separated, and someone yelling, "Please don't," or not please, "Don't put your hands on my children." I said it's coming way up there to that point, but to see people being separated from what I assume was a confrontation.
Okay, so I know that this is like a courtroom and we are proper, however, you can use the real words.
Okay.
So if there were cuss words used, please feel free to use
Yeah, they
them.
said, please, don't put your hands on my fucking child.
And is that what you've heard being yelled?
Yes.
Okay, so,
She was screaming that. Absolutely screaming that. "Don't put your hands on my effing child." All right? There wasn't just a calm thing. The people were angry and the people were mad. Or Perla. It's not the defendant. So they're screaming at him. And not enough that Bell hears it. Next thing that happens. Their story. Jose Rodriguez tries to play peacemaker. Wrong again. That didn't happen. Wrong again. Jose goes right up to Devonen Briggs, who's still sitting down. All right? He's very close to Devonen Briggs. Perla's right behind him. He is right behind him. And Jose Rodriguez is angry. And how do we know this? Because even Perla had to try to restrain him. Perla had to try to pull him back. Perla used force to try to pull him back. Let's see if that isn't the case, but that's exactly what Perla said.
You were close enough to, Jose was, Mr. Briggs, that you even tried to push Jose back, correct? That's what you told police.
That's what I said at the moment.
That's what I said at the moment. That's what she told police, and that's what happened. That's what she said. Jose Rodriguez was right on top of him. She was afraid Jose was going to do something at that point, so she tried to push Jose Rodriguez back. All right? Again, their whole scenario is falling apart. Everything they said happened didn't happen. It happened in reverse. It happened in reverse. And let's remember this. Witness after witness after witness after witness said, and said, back up. Back up. Back up. This guy's not looking for a fight. Back up. But they kept coming. They absolutely kept coming. And even Jose Rodriguez said Perla told him, drop it. Let him go. Let's see that.
And you say some things.
Yeah, I did.
What do you say?
I told her that he wasn't gonna disrespect my wife and he shouldn't be arguing with a woman. I mean,
Right? Is that the way you said it, or did you
I
say?
probably use cuss words like you shouldn't fuck, you're not gonna fucking disrespect my wife.
Okay.
Don't be arguing with a woman.
Okay. And so you said that. Then what happens? So people are hard. You told us what people were exchanging words and they're angry. What did you do at that point?
Well, after I told him that, my wife kind of grabbed me and told me to just drop it, to let it go.
Perla told you to drop it and let it go.
Yes.
When your wife told you to drop it and let it go,
We started kind of like talking between us, trying to, I mean, I was already angry that someone had yelled at my wife,
Okay.
so she was trying to calm me down.
all right.
She was trying to calm him down. Perla, who was already angry herself, who was yelling, don't put your effing hands on my child. She's trying to calm him down because Jose is angry. Don't you understand? They have the whole narrative reversed about who's upset, who's angry, who's mad. They got it reversed. He's angry. He's upset. Perla's trying to calm him down. Let's keep going. They say that the defendant made remarks, and they said racial remarks. Well, first of all, let me tell you that the remarks he made, the statement that is made about Mexicans, it's wrong. We own it. It's stupid. He shouldn't have said it. It's ignorant. But the question is, did he ever say those words? Did he ever say Mexican at the Olive Garden? And the answer to that is no, he did not. He did not use racial epithets or racial words at the Olive Garden. If you don't believe me, ask Jose Rodriguez when he's first interviewed. He's asked the question, did he use the word Mexican? That's in his first statement to police. Before they've seen a lawyer, before they've talked about hate crimes, before any of that. Did he use the word Mexico? No, he didn't say the word. No, he didn't say the word. And sitting next to him, right next to him, standing next to him is Perla, and she never mentions, yeah, he used that. Now, you don't have to rest just on what Jose said. Zach Moore was one of multiple witnesses. He never heard any racial epithets. Hack, and he's sitting right across from him, Hack didn't hear any racial epithets. Bell said Bell didn't hear any racial epithets. O'Brien didn't hear any racial epithets. They're right there. And you know who else didn't? Michelle Hopper. She was their witness. She said she heard none of that. None of that. This is Mr. Moore, who's totally impartial, doesn't know my guy, never seen him before in his life. Let's see what he said.
Ever hear the African American male say anything racial?
No, I never heard anything.
Would he lie? He's sitting right across from him. Right across. Here's Miss Halber, who was one of their main witnesses. Same question.
Everybody was saying all this racist shit, but I never heard anything like that come out. Is that correct?
Yes.
Okay.
Yeah, after the fact. Oh yeah, people were trying to come up with this racial hate crime. She was right there. She saw it. They called her. Nothing. There was nothing like that. Devin O'Brien didn't hear it. Hack didn't hear it. Nobody heard it. Except for Churn and, Pearl and Rodriguez and so forth. She's there. She testifies for the Commonwealth. She said, my client said, oh, he used profanity, whatever. She says, no racist comments. That just should be a non-issue in this case, because it didn't happen. Let's keep going. There were no racial remarks. What happened next? Things calmed down. Things calmed down. And then Linda gets involved. What did Jose Rodriguez say about Linda? What did he say? They didn't even want to tell her because she had a temper problem. She would get angry. They were even having her go to counseling. Jose Munoz and Linda were always arguing in public. That's probably why Jose Rodriguez, send her to counseling, let's see what we can do. When this whole encounter began, Jose Rodriguez looked at, and they said, and Perla said, let's not tell Linda, because Linda knows. Because Linda will go off. That's what they're afraid of. That Linda would use her temper, which is exactly what happened. Let's listen to Jose.
Right, but I'm asking you, you all didn't even want to tell her because of her issue, correct?
No, because we didn't want any problems with anybody.
All right, now,
We didn't want any problems. We didn't want any problems, he says. That's why they didn't tell Linda. That's why. All right? But somehow, Linda got involved. And she started it. She started at the defendant. And if you're wondering why maybe the defendant did say some things, even not racial back, she said, why do they let people like you out of the box? My client didn't make that up. He didn't make that up without a lawyer before he'd ever been to court. She said it. I don't see how they put people like him out of the box. All right? And she said it. And every time I asked, I asked Perla, I don't recall. And then finally she said, no, we wouldn't have. But it's, I don't recall. Linda, I don't recall. Jose Rodriguez, I don't recall. I don't recall? How about we didn't say it? How about it never was said? How about it didn't happen? They didn't say that because it did happen. That's what they said. That's what Linda with a temper said. I don't see how they let people like him out of the box. And if you think, well, this man would suddenly make that up, all right, on the spur of the moment, when he's talking right after there. No, he didn't. That's what she said. And what else was Linda saying? Let's listen to Jose Rodriguez.
I believe it was Linda that said something about that if you don't like fucking kids, shouldn't be around the garden.
All this while, this Perla's coming up, screaming at him. As Jose Rodriguez is coming up, just right up on him, has to be restrained. And Linda's screaming it at him. And the F word's being thrown. What to do? Continues to sit down. He continues to sit down next to his wife. He doesn't even get up. Doesn't even get up. What do they say happens next? What do they say happens next? Well, ladies and gentlemen, what they said happens next is where their case completely, totally falls apart. Completely. Collapses. Their story is that at this point, Devonen Briggs gets up. First story that's false. That he walks over to where Munoz is. Second part, that's false. 3, that he chest bumps Munoz. In other words, that he starts the whole encounter and that Munoz just pushes back just because he's defending himself. In other words, they're saying Briggs left the bench. Briggs walked over. Briggs confronted. Briggs check spunked. It's all a lie. Every bit of it. And their story collapses under their own witnesses and their own proof. Their story absolutely collapses because it's all the other way around. Let's start. Who goes to whom? The person who confronts, the person who's the aggressor, the person who goes is Jose Munoz. My client remains seated. Munoz approached him. All the witnesses say that, except the Floreses and Rodriguez. All of it say that. Let's see who says it. Kyle Young says it. David O'Brien said it. Zach Moore said it. Alexander Hack said it. Stephen Bell said it. There was no approach by my client, let alone chest bump. Let's listen to Mr. Hack.
You never saw the African male chest bump anybody, correct?
Chest bump? No.
No, that never happened. No. In fact, until the Hispanic male approached, as you stated, Mr. Briggs had stayed where he was the whole time, sitting on the bench.
Yes.
He stayed where he was, sitting on the bench. All right? All right? He didn't approach anybody. He didn't confront anybody. Kyle Young, was there a chest bump? Again, Young doesn't know our client. Let's see what Young says.
After the door opened, did you ever see the black man come up and, for example, chest bump the Latino man before he was pushed?
No.
Didn't happen. It absolutely didn't happen. All right? So, Kyle Young, no chest bump. Hack, no chest bump. Moore and O'Brien and Young. My client sat there while the other man approached them. Let's keep going. When Zachary Moore, what was my client doing? Not only did he confront him, let's see what Moore says my client said.
Remember him asking them to back off?
Back off? The opposite of what? Back off is what Moore said he said. In other words, not only is he not approaching, he's begging them, asking them multiple times, don't come closer, back off, back off. Does that look like a man? Does that seem like a man who's looking to cause trouble? Let's listen to Mr. Hack.
He kept saying, you need to back up, you need to back up, you need to back up. He said that multiple times. He kept saying this to the Latino man. Is that true?
Yes.
And Kyle Young, right before the shooting, what is the word that he hears? What word do we hear that he says he hears?
Look through the door. You said the very first thing you heard was some voice saying, get back, or you need to move back. Back up. Back up.
That's what he said. It's absolutely what he said. You need to get back. He said everyone in the world, please back up, back up, back off, back up. He wasn't trying to cause any confrontation. So this whole thing of our client getting off the bench, being the initial aggressor, chest bumping somebody, that didn't happen. And their witnesses told you it didn't happen. They swore it didn't happen. They said it didn't happen. It never happened. They've spun the truth, so it's the opposite of what the truth is. An absolute opposite of what the truth is. All right? So then, what actually happened? Munoz approaches him. My client tries to stand up, and he can't even stand up. Remember, he's in the corner. He is in the corner, or right next to the corner. He's against the bench. He can't get back any farther. Let's listen to Mr. Bell, prosecution witness, works for Olive Garden. Let's listen to Mr. Bell.
You confront the guy who thinks at fault, correct? As soon as that guy stands up, boom, against the wall, correct?
Give him a shove, yeah.
That would make sense to you, right? And that's what you saw that day?
Yes.
Okay. Now, when you say the guy that was shoved, black male that was pushed, he kind of collapsed against the wall. You said
Leaned against the wall, yeah.
What you're really saying is that the wall broke his fall after he was pushed, correct?
Essentially.
Essentially, right? Because if there hadn't been a wall there, it would be nothing for him to fall
Probably
against.
fell on his butt, yeah.
Right? He was pushed hard enough to fall down,
It was, yeah.
and the wall broke the fall.
Yeah, like,
So where's he going to retreat to? Where's he going to run to if that's what he's going to try to do? Where's he going to? He is pushed back so far, his legs are against the bench. The only reason he wasn't on the ground is that the wall was right there. All right? The man is on top of him. They admitted, even Churn said, yeah, he was on, Munoz was on top of him. That's what she initially told police. Stephen Bell's got him pushing, and my client would go down, but for the wall right behind him. Where's he supposed to go? Where's he supposed to go? And what happens? What is Munoz's intent when he goes over there? Was it to say, hey, let's talk about it? Was it to say, let's calm it down? We know what his intent was. Let's listen to the witness, Devin O'Brien.
For sure, he went over there to punch him, is what you believe.
that or assault him.
Pardon me?
That or assault him, or it looks like it.
Looked like he was going to assault him. All right.
And he's still sitting down. All right? And when he tries to get up, boom, he's back down because he can't even get up. He was going to be assaulted. Whatever you decide or think in this case, you got to understand, he was going to be assaulted. They were going to punch him. And I submit they were going to punch his lights out, but they were going to punch him. They were going to assault him. That's what they were going to do. That's Devin O'Brien, no reason to lie. They were going to punch him. All right? And it's not that they were going to punch him. That they, remember Devon said they were going to maul me, they were going to take me down. I was fearful of that. O'Brien, he was going to be assaulted. What else? How do we know he was going to be assaulted? Well, let's keep looking at the proof. He was, quote, remember, Jose Rodriguez is right behind. They have a triangle. They're within inches of this man. Let's listen to Jose Rodriguez.
Mr. Rodriguez, what you said is that Jose Munoz got very close to Devonen Briggs, correct?
We were all very close.
Yeah, they were very close, all right. And we can tell you how close, because we have the benefit of a medical examiner. But he was very, very close. They were basically on top of him. And what was the intent? He says now 14 to 16 inches, he was even closer, but let's listen to him. Maybe 14 to 16 inches when they're 14 to 16 inches.
When he got shot?
Right. And that's how close he was, correct?
Yeah.
Wow. He was closer than this, but this is 12 inches. And he was closer than this. He was much closer than this. All right? So, my point is, Munoz is on top of him. He's 14 to 16 inches, even closer than that. All right? And what was he going to do? It wasn't just that his intention was to assault. What was he going to do? He was going to punch him. And how do we know that? How do we know that? We've got Miss Halber and we got Mr. Hack. Let's take a look.
That hit. Explain to me what you saw the Hispanic male do for the African American in terms of hit.
He punched him.
And they try to get her to say, well, was it a push or a punch? And she ends up saying, I know the difference between a push and a punch. It was a punch. And you know, you can knock someone out with a punch. You can break their teeth with a punch. You can give somebody traumatic brain injury with a punch. But beyond that, does anyone believe that that's the last punch that would be thrown? with Jose Rodriguez angry and right behind, and Munoz mad, and he's walked over there, and he won't even let him stand up, and yes, he punched him. That was the first of what was going to be multiple punches. It was going to be just what he feared, beat down. They were going to punch his lights out. And let's keep going. You know the difference between a punch and a push? Yes, I do, she said, and it was a punch. I'll tell you who else saw a punch. That was, Kyle Young didn't see it, but he recounts to police what he saw. And he saw that, he recounts how Casey, his brother, saw the punch. And Mr. Hack told you that he saw. They tried to say he didn't, but he showed him. The man had the last thing Hack sees is Munoz had cocked his fist. And cocked was the word of Mr. Hack. He cocked his fist. That's what he did. Why? Because he was going to punch him and was in the process of punching him. And it would have been the first of multiple punches, but for the shot. So everything they told you here is my client went to them? No. My client was the aggressor? No. My client chest bumped? No. They weren't going to do anything to my client? No. They came over there, wouldn't let him get up, shoved him down hard, and then they were going to punch his lights out. That's the truth. And how close were they? How close did they get? You know, it wasn't 12 to 14 inches or 14 to 16 inches. It was even less. And how do we know that, ladies and gentlemen? How do we know that? Well, remember the medical examiner testified. And he said, the scientific report, it was, the shot came, he estimated within 2 inches. That's right here. You talk about getting on a stranger within 2 inches and punching them. That's how close they were. And we know that from the science because Dr. Springer said there was stippling. That wasn't a contact wound, but he described almost a contact wound. That's how close they were, 2 inches from the man. Inches away, having yelled at him, screamed at him, cursed at him, having Rodriguez come first, Perla trying to restrain him, then Linda's screaming at him, then Linda's cursing at him, and then Jose Munoz is there, and they're on top of him, absolutely on top of him. And then I asked Dr. Springer, I said, is your science, is your autopsy consistent with the deceased, the victim, being on top of Mr. Briggs? And he said, yes. Your scientific report would be consistent with that idea that the victim was on top of the defendant, correct?
Yes, it would be consistent.
And he also goes on to talk about it's almost a contact wound. Or case, for a layman's term, this is almost. It's not a contact wound, but it's almost a contact wound. Correct?
It's pretty close.
That's how close it is. Contact would be right here. The 2 inches is right here. That's how far the man was on top of him, over him, on top of him, and that's totally consistent with the truth and what happened. And that is consistent with the science. That is the science of this case. So whatever you do, the context of this case, the truth is Briggs didn't get up. Briggs kept his seat. They cursed him. They went to him. Rodriguez went first. Perla tried to restrain Rodriguez. Linda got involved. He stays seated the whole time. He stays seated even though he's, F this and F that. Then they go to him. He didn't go to them. He chest bumped nobody. When he tried to stand up, they shoved him down so hard he would have fallen. And then after that, after they did that, Munoz was ready, and I think would have, but for the shot. He was probably in the process of punching the defendant. Now that's the truth. We can argue about what should happen, but the truth is what I've told you. And what they told you in terms of that facts wasn't true. What we told you is true. Their witnesses showed it. We showed it. We don't have to prove anything. That is what true. They were going to punch his lights out. All right. Let's pause here for a second. Did the defendant flee? No, he didn't. Detective Chris McCandless said no, he didn't. Right after the shots, it appears from his statement that Brittany had gotten scared and run just prior to the shots. This is based on Briggs' statement. Because he looks around, he can't find her. He says she's outside, but he hears her yelling. What's going on? Or what's up? And he says, look, we got to call police. We got to get out of here, but we got to call police. They then go to a parking lot 2 blocks away and call 3 times. Okay? In fact, he even says one of the times they called back, but I may have hung up too soon. So there's no fleeing. They didn't say they were fleeing. In fact, Chrisman said it wasn't fleeing. Second thing, holster. Look, the law doesn't require a holster. Just does not. He had to have the permit at that time. He had the carry and conceal permit. Holster wasn't required. He didn't want to, off-put or threaten people or intimidate people. He didn't wear a holster. 3, people have different views about having a gun in a public place. All right? But he had the license. The state said go to a class way back when. He took the class in 2013. He passed the class. He did the training they required. All right? And they issued him a certificate. And then he got it renewed in 2018. The gun he bought was legal. He'd never used the gun except at a target range. Ever, ever, ever. He did what the state said. They said you can carry a gun concealed. He did it because they said they could. He got the training because they said he had to do it. They said go to the classes. He did. He got the certificate, and now they want to hang him for it. And if they don't want people to have guns, then they need to pass a law saying you can't carry concealed. But what you can't do is tell a man you can carry concealed, do what you're supposed to, take the class, get the certificate. We'll issue a certificate and then say, boy, we never meant that you use it. We never meant that. We never meant that at all. You're going down. Let's keep going. They may talk about his demeanor. Well, ladies and gentlemen, people in tragic situations, demeanors can vary incredibly. People can undergo horrible tragedies and yet very calm. Doesn't mean they are calm. People can undergo minor events and they become very emotional. I think at one point, the detective Grisman at one point laughs. It doesn't mean she's not taking it seriously. She is. She's trying to relax the defendant and have him talk. The important thing is not how, well, I would have reacted this way or I would have reacted this way. Is what he said true? And everything he said, ladies and gentlemen, everything he said about them approaching him, pushing him down, falling back, becoming afraid, everything he said was the truth. And that's the important thing, the absolutely important thing. They're also going to say, well, what about this trajectory? It doesn't matter whether he believes a bullet's going up or down, whether it's like this or like that. He's trying to recount something. Let's remember, this is split second stuff. And he's trying to recount it the best he can. But the point is, And the main point is this: the reason that the bullet's down is the man was so close. He couldn't even get up there. He was on top of him when the shot was fired. Munoz was. Even Chern said that. He was on top of him. That's essentially what the medical examiner said. All right? He was on top. So Munoz being on top, that's why, and 2 inches away, that's why he can't even extend his arm. And that's why the shot is going down. He couldn't even extend his arm. So the shot goes down because, let's remember, it's from 2 inches away. All right? So the fact is, none of these things, the fleeing, the holster, they don't mean anything in the case. He's telling the truth, and he tried to tell the truth as best he could remember, and that's what he did. All right, let's go, if I can, to the instructions. And what I want to do is kind of give you a framework to look at the instructions. All right? Because I think we can, basically come up with a framework here as a way to approach it. You start, the top charge is murder, intentional or one. There's no really, in Kentucky, the penalty's the same. It's murder's murder, whether it's intentional or one. Okay? And one thing you got to do, one of the first things you have to do, is go to self-protection. Instruction number 7. I'm sorry. Instruction number 6. Self-protection. Okay. You're going to see, when you look at this instruction, that the defendant's belief is really important. Really important. Okay? And we said that in voir dire. You have to figure out what the defendant believed at the time. Okay? And under the instruction 1, if at the time he shot, he believes it necessary to protect himself against force, including the right to use physical force. You can shoot somebody if he believed it necessary to protect himself from death or serious physical injury. If the defendant believes it, then he's not guilty of murder. He may be guilty of other offenses, but if he believes it necessary to protect himself, he's not guilty of murder. Belief is critical, and he did believe it. Now let me repeat that. If you believe, if you believe it necessary, even if you're wrong, you're not guilty of murder. We reserve murder for that cold-blooded and intentional, where, hunting down a man, or wanton murder, putting a bomb on a plane. If you believe, even if you're mistaken, even if you believe it necessary, if you believe you have to use the gun, because we don't want to fill the prison with people who make mistakes. If you believe, even if you're mistaken, you're not guilty of murder. All right? That's critical. And there's no doubt that Devonen Briggs believed that he needed to defend his life from serious bodily injury or worse. Let's listen to him before he has a lawyer.
Or I felt that he was going to mob me while I was sitting on the bench.
He says,
I was by myself, but with people down, I was going to go down.
And when you say go down, you mean like they're going to take you down?
Yes.
Or
let's keep going. He even used to saying he has to defend himself. He states that. He has to defend himself.
Y'all escalated to this. Unfortunately, I got to defend myself.
He says again and again, they're going to maul me. They're going to take me down. They're going to punch me. They're going to, I got to defend myself. I'm going down. So there's no doubt he believed that was what was going to happen to him. All right? All right. So that takes you out of murder. All right? And you go to the lessers of manslaughter second and or reckless homicide. But he believed, and under these instructions and under the law, if you believe you're acting in self-defense, you're not guilty of murder. And he's not guilty of murder, which is reserved when there's no excuse, no nothing. All right? No nothing. So, let's keep going. Let's go, if we can, to manslaughter second degree, all right, which is instruction 9. You start with murder. We're asking you to find not guilty on murder. You then go to manslaughter in the second degree. Now, what that is this, and this is a simple way to look at it, okay? There's no doubt they were going to beat him. There's no doubt that they were going to take him down. But the Commonwealth may argue, was in number B, 3B, the degree of force necessary? He may have been wildly wrong in there. That he may have, quote, in 3B, disregarded a substantial and unjustifiable risk that he was mistaken, and that it was a gross deviation from the standard of care. Now, if you believe that, and you believe beyond a reasonable doubt, if you believe that they're only going to hit him once, that maybe he would have just glanced off him, that Jose Rodriguez wasn't going to join in, that he could just sit on the bench and things would have turned out just fine. All right? But I don't think my client was mistaken at all. I think he was right. And even if he was mistaken, he wasn't off the charts wrong. Let me give you an example of this gross deviation. You drive on the water the wrong way at rush hour. You know it's rush hour, you know you're going the wrong way, and you go ahead and do it anyway. It would be the equivalent of saying, this guy's no problem. He may hit a glancing blow. I got no problem. I'm going to defend myself even though I well could be mistaken. That's not what happened. He's processing in a second. Remember, we talked about at the time, not looking back, not in the courtroom, at the time, under the circumstances as he believed them. He believes that this guy is going to punch his lights out, and what else could he believe? The man's come up to him. He's forced him down. He's cocked his fist. He's punching. They've cursed him. First it was Perla yelling, then Linda. Rodriguez's yells got right up on him. Now they're at him, and yet the last time, the fourth time, and they're putting his hands on him with that shove. You know? People, we haven't like to talk about this case, how someone feels if you put their hands on them. When you're sitting next to your wife at a public restaurant, how do you feel when someone puts his hands on you and shoves you back down and you're in the corner and you can't get up and the guy's cocking his fist and he's swinging? I don't think he was wrong a bit. I don't think he was wrong at all. But even if he was wrong, he wasn't off the charts, gross deviation wrong. He was right, okay? The man was right. And when that fist is cocked and it's coming forward, you know, with one fist you can break a man's teeth. You might knock him out. You could knock him unconscious. And that's just punch one. So before people start saying, well, should have done this, should have done that, that's all Monday morning quarterback second guess. You think how anyone would feel when you put your hands and you're trying to sit next to your wife and you try to stand up and you're pushed back so hard you can't even, you're against a bench and the man's on top with you within 2 inches and punching. Go. Instruction number 10, reckless homicide. I'm asking you to find not guilty of manslaughter 2. So now you're on to reckless homicide. It's basically the same thing, ladies and gentlemen. It's basically the same thing. It's just you're off the charts wrong. He believes he needs to use self-defense, but he's off the charts wrong. He just doesn't realize it. He's driving the wrong way on the Watterson, but he doesn't know he's going the wrong way. He, again, wasn't wrong. He wasn't off the charts wrong. He wasn't wrong, period. All right? They were going to take him down. as he said. And that's why they were both over there, and that's why they were so close, and that's why the fist was cocked, and that's why they were going to teach him a lesson. They were going to take him down. And that's the truth, and that's the fact. And if we don't like a gun in a public restaurant, then change the law. But don't make him pay when they came after him, which they did, and they were going to punch him down, and they were going to give him a good beating, and just sit there and hope nothing happens. All right. He's not guilty of reckless. All right. Now, one of the things, you think about and you appreciate, I think, more as you get older. There's no doubt. Every life is precious. And, I get more aware of that every year. Because you lose people. Every life is precious. And there may be thought, there probably is a thought, that just take a beating. Don't use the gun. Just take a beating. All right? You'll probably survive. Just let him beat you. Or put up a hand or do what you can, but take a beat down. And the best analogy I can think of when I was thinking about this is this. Over the years, there were times when I represented women who were abused, battered, and at some point they would defend themselves and shoot the abuser. And it was hard to defend legally because at the time of the shooting, the beating was about to come, and it hadn't happened yet, or it had just happened. In other words, the woman would choose a time when she could defend herself. But the shooting wasn't always during the beating, and that made it hard to defend. And I remember people saying to me, in a couple of those cases, "Well, Rob, you know what your client should have done? Your client should have taken a beating. Shot during the beating, it wouldn't have been a problem. She should have taken a beating." Well, things change, people change, law changes. All right, let's go, if we can, back to instruction number 6. Let's go back to instruction number 6. Number 2. A person who is not engaged in unlawful activity. He was not. He's sitting his wife at a restaurant. And who is attacked in a place where he has a right to be. Yes, he's in a place where he has a right to be. Was he attacked? Yes, he was. He was shoved, he was punched, and the worst was yet to come. He has no duty to retreat. No duty to retreat. He couldn't have retreated anyway. It was against the wall. But he had no duty to retreat. And he has the right to stand his ground. He has the right to stand his ground and meet force with force. Now that's the law. He has the right to stand his ground. You don't have to retreat. And meet force with force. Okay? To present, if you believe it's necessary to prevent death or great bodily injury. What? A grown adult, a punch right here, a punch to the eye, you could have a detached retina, a punch to the teeth, you could have a broken jaw, and that's just with the first punch. Or to prevent, look at the words here, commission of a felony involving use of force. You punch somebody, you break their jaw, that's a felony. And that's punch number 1. My point is, you don't have to run. You don't have to retreat. You don't have to hide. You can meet force with force. You can stand your ground. You don't have to take a beating anymore. Let's go to instruction 7. Let's go to instruction 7. All right? Instruction 7 talks about initial aggressor. Who's the initial aggressor? They say, well, if he was the initial aggressor, he cannot use self-defense as a defense. If you get to that, look at instruction 7, number 1. If you believe beyond a reasonable doubt that the defendant was the initial aggressor in the use of physical force. He wasn't. He was not. He absolutely wasn't. The other Munoz came over, pushed him down, and then was punching him. My client wasn't the initial aggressor. So you can forget about this initial aggressor thing. My client's entitled to use self-defense because he wasn't the initial aggressor. Munoz was the initial aggressor, and that's their proof. Look at that again. If you believe beyond a reasonable doubt that he was the first initial aggressor in the use of physical force, he wasn't. It's the opposite. Munoz was. As soon as he laid his hands on him and pushed his back, that's the initial aggressor, and it's Jose Munoz. You don't need to get farther than that, but if you look at B. The defendant withdrew from the initial encounter and effectively communicated his intent, and Munoz continued to threaten or use force. My client repeatedly says, stand back, stand back, stand back. He says it again and again and again. All right? Again and again. My client's trying to communicate, just stop. So he wasn't the initial aggressor, and he said, please stop. Let's keep going. They may say somehow my client provoked Munoz. All right? And again, this is just off the charts, not what happened. If you believe from the evidence beyond a reasonable doubt that the defendant provoked him to use physical force, in other words, my client deliberately provoked Munoz. And then he did so, look at this, he did so, and again, with the intent of causing death or serious physical injury. All right, I'll sit here on the bench. All right, I'll make a few remarks. I know that this will provoke Munoz. I know he'll come over. I know he'll push me down. I know I'll barely be able to get up. I know he'll punch me, and now I can use my gun. Give me a break. Give me a break. That's not what happened. And if he was so intent on provoking, how do you provoke someone when you say, back up, stand back, stay away, stay away? How do you provoke someone then? There is no provocation. There is no initial aggressor. This is a self-defense case. And that number 6, stand your ground, is what this case is about. It's what this case is all about. So, ladies and gentlemen, what happened here? I'll talk about the wanton endangerments now and go to what happened. The wanton endangerments are very simple. Okay, those are people who were not hit, and they're somehow saying that by firing the one shot, he endangered others. And you have a choice of wanton endangerment first or wanton endangerment second. And we're asking to find him not guilty of both of them. The difference is this. Did he create a substantial danger of death or serious physical injury? That's wanton endangerment first. Or did he create just a substantial danger of physical injury, not death or serious physical injury? Look, the shot was from 2 inches down. Okay? Nobody else was in danger. He acted in self-defense, so he can't be convicted of wanton endangerments. Otherwise, you could get convicted of that even if you acted in self-defense. But beyond that, the shot going down like this, almost a contact wound, there's no way on this planet that it could have hurt anyone. And even though it went through, no one was They haven't even shown that anyone was near this thing when it went through Mr. Munoz. And besides that, it has to be, and you'll see this, that there's a substantial danger. There was no danger because the shot was from 2 inches downward. There's no danger to anybody else. And so he should be acquitted on all those wanton endangerment charges. So let's go, ladies and gentlemen, to what happened here. What happened here in this case? They came in and they were upset, okay? Pearl is mad, and she's at him. There was no pushing of the child, but she's at him. Get your effing hands. Even so, maybe things calm down, but Jose's on top of him. Jose's up real close to him. So angry. I'm angry, and talking to my effing wife. He's on top of him too. Enough that Perla thinks Jose's going to assault him. He doesn't, but Perla's trying to restrain Jose. Rodriguez. Then they come up with another wave. Linda F this and F that. Then she has the box remark on him. Maybe she had that. So it's one after the other, after the other, after the other, and he still doesn't do anything. But finally, when they're getting ready to do a beatdown, and they're both over there, and they're within inches of him, and they're punching him, you tell him! You just sit there and take it. They're going to take him down. They're going to take his bunch of lights out. They're going to give him a good beating or worse. That's what they were going to do. That's the truth. That's what we're going to do. He doesn't have to take it under the law. He doesn't have to take a beating. He doesn't have to hope things turn out. He doesn't have to hope that his wife can go home that night and he'll still be there. Doesn't have to. He can defend himself, his life, his bodily integrity. He can defend everything he's got when someone puts his hands on him. He's not a killer. He's not a murderer. He's not guilty.
Thank you, Mr. Eggert. We have been going a little over an hour and a half, so I'm actually going to take a 10-minute bathroom break, and then we will proceed with the Commonwealth's closing. So same admonition applies. Do not discuss this case with anyone, including each other. Don't do any independent research, and do not form any opinions about this case. And if you please gather back outside the doors in 10 minutes. Thank you.
All rise for the jury.
Counsel, could you please approach? Juror number 12 was asleep again. I thought he was going to fall out of his chair. He was leaned so far forward.
Was this the same one?
It's the same one, so I just want to make sure, is there an agreement to strike him, or is there any objection to striking him?
I think we do.
Okay, I'm going to go ahead and pull his number out before I actually do the random draw. How long do you think your all's closing is going to be?
Do you have motion we're at
1:30.
1:30?
I would like to have
I'll
like.
be okay before. If there's, I know, I would like
Yeah.
to disagree.
Maybe before that.
Okay, well, I'm going to have to look at the motion hour stuff out here then, I guess. Okay.
Or we can do it after. It's whatever you would like.
No,
I
no.
really don't mind either way, so.
Okay. All right, I'm going to take us off the record.
Well, then
Mr. Eggert was out there. Go grab him. I'm gonna give you till 1:20, okay? So just keep an eye on that clock.
I can go grab him.
Surely God, we can get it done by then.
Judge, the sheriff and I went to get Mr. McGee. I think he's coming right.
Okay, I see Mr. McGee.
Good, we're good.
Now I'm just waiting on,
But that's where I was.
All right.
do we have everybody? Actually, Mr. McGee, since you're, do you mind setting this on the jury, in the jury box? Yes, thank you. All right, let's bring them in. Thank you.
All rise for jury. All jurors present, Your Honor.
Thank you. Please be seated, everyone. Were there any issues with the admonition over the break? All right. We are going to continue now. I know you all are probably hungry. Once the Commonwealth is finished, you will be leaving to deliberate, and lunch will be waiting for you. So I appreciate your patience. Ms. Perfumo?
Yes, now that I am what is standing in between you and food, let me get situated. Okay. May it please the court, counsel, ladies and gentlemen of the jury, thank you for your service, and thank you for being here all last week and whatever portion of this week you're going to have to be here. We appreciate your time, and we know it's not an easy task to be on a jury, so thank you. So, defense counsel has made a great effort in trying to distract you from the facts of this case. In order to paint the defendant in the light most favorable to him, they have lied to you. Mr. Eggert has lied to you, blatantly. And it is in the surveillance, or it is in the interview of Mr. Briggs with Detective Chrisman. You can go back, you can watch it yourself, you'll take it back with you. I urge you to watch it. Listen to what defense counsel has told you and realize that they lied. It's the same situation as the defendant put himself in on the night of February 23rd, 2019, when he told police the facts in the light most favorable to himself as well. And here we are again 4 years later, and they've had 4 years to prepare a defense for this, and that's their defense. It's to lie to you. I would just ask that what defense counsel is wanting you to do is base your decision, whatever decision you make, on emotion. I'm going to urge you to combine emotion and fact. It's fine to use emotion, but also apply the facts of this case. Last week during jury selection, we discussed why people lie. And it's to save themselves, to avoid consequences. And that's exactly what Devonen Briggs is hoping he can do today. Avoid consequences. by convincing you that he murdered Jose Munoz because he had to. He didn't have to. He didn't have to.
Judge, may I approach 1 second?
You may.
I'm sorry to be very brief.
I would object to them calling me a liar, Judge. I mean, they can say our witnesses lie. I object to being, I stand my client's views. I object to being called a liar.
I couldn't do the objection.
The objection is to Mr. Egger being called a liar. Ms. Perfuma has
Yeah,
reviewed
you're
it.
characterizing counsel.
Well, he did.
I know, but okay. Let's phrase it.
Okay.
You're saying that what he told you was not true.
Okay.
He made summation. That's a better way to say it.
Okay.
No.
Yes.
You did. You said you can't say that.
Okay. I'm sorry.
Yes, I would avoid the inflammatory remarks about counsel.
Okay.
I'm going to sustain the motion. Okay, but you're welcome to tell them that.
Can you say to ignore those remarks about Mr. Egger? Because I would appreciate it, and I didn't call them a liar.
I haven't said untruthful things.
Yeah, you said I was a liar.
One thing is
That's what she
did
said.
you use that word? No, but did you? You said this is what they told you, and it's all.
And then I went through the proof. I didn't say they
I'm
lied.
also going to go
I
through
said their witnesses did. I never said they lied. She said I was a liar. Mr. Egger's a liar. I'd asked for the admonition to ignore that statement about Mr. Egger.
Okay.
We would like to rephrase it. It's first time out, okay?
Yeah, but
So just saying he's being dishonest.
Yeah. No, I think we got to.
I'm still
talk
called a
about what
liar
to
in
say.
front of the jury, and I stand in my client's shoes.
I will give the admonition of the jury is to disregard any allegations or any statements by the Commonwealth that Mr. Eggert and Mr. McGee are liars.
Would the court consider an admonition that says that both the parties can disagree about the evidence?
She can say that.
The parties, when they disagree, that appropriately is that we're going to about they're disagreeing with the evidence and how it's presented, and we're not talking personally about the attorneys involved in it.
Okay, so parties may disagree about the evidence in this case, but you are directed to disregard any statement by the Commonwealth.
No, we didn't say
about
anything about it. You've already decided what to admonish him, and I'd object to this reconsideration and so forth. And as you say, disregard it.
I will add in the qualification, though, that the parties may disagree about the evidence.
And neither party is to characterize the others.
I didn't categorize him. I don't need
You
an
did,
admonition.
but it wasn't as strong. I agree with that, but you did. Here's what I feel bad about, Your Honor. We come up and she's like, well, I want to say that I don't agree with the facts, and I was like, yeah, be aggressive. So I think I did not say the word lie, but I think I put my junior counsel in a bad position to say that. I agree. We wouldn't say that. I wouldn't say that about you. But
It's all
Just
right.
the
It's
admonition,
not-
what you said.
It's okay. That's what the admonition is for.
mm-hmm.
Thank you.
I'm not, you know.
All right, thank you.
All right, it's okay. Okay, ladies and gentlemen, the parties may disagree about the evidence in this case, about what the evidence shows. I am directing you to disregard any comments by the Commonwealth that Mr. McGee or Mr. Eggert are liars. All right, thank you. You may proceed, Ms. Perfuma.
Thank you, Your Honor. Let me go back a little bit. Okay. Like I previously stated, this is where I urge you to consider two things combined, emotion and fact. Last week, during jury selection, we discussed why people lie. I know I just said this, but it is to save themselves from any type of consequence of their actions, which is what Mr. Briggs is doing right now. Defense counsel is trying to convince you that Mr. Briggs only shot and killed Jose Munoz because he felt he had to, but he did not have to. And how do we know this? You heard testimony about how Jose barely spoke English, not enough English to formulate threats. In fact, Devonen Briggs even said himself that Jose never said one word to him. no intent of, I'm coming, I'm gonna get you, no words were said at all. And yet, Devonen Briggs pulled out a gun and shot him anyway. You heard testimony that Jose didn't own any weapons and that he was unarmed on the night of this murder. And yet Devonen Briggs still felt he needed to pull out a gun and shoot him anyway. You heard Devonen Briggs himself say, "No, I was chill," in the interview with Detective Chrisman. I was chill when he was describing his demeanor that night, and yet he pulled out a gun and shot him in the chest anyway. You heard Devonen Briggs tell Detective Chrisman that Jose was the only person in front of him when he shot him. At this time, I'm going to ask you to follow along with me. Open up your jury instructions to page 8. Just to recap, on February 23rd, 2019, Devonen Briggs put a loaded gun into his waistband, walked into a crowded Olive Garden, pulled that gun out, turned the safety off, racked a bullet into the chamber, placed the muzzle of the gun against Jose Munoz's chest, and pulled the trigger. Devonen Briggs took Jose's life that night in front of his young children and his fiancée. Why? Because a 4-year-old stepped on his shoe. A 4-year-old touched him. You're sitting here today with all the tools that you need to render a verdict. You've heard all the evidence, and now you're in the final stretch. You've been provided jury instructions, and soon you'll be asked to apply the evidence that you've heard in this case to the law that sits in front of you. In a bit, we will ask you to find the defendant, Devonen Briggs, guilty of murder, along with 7 counts of wanton endangerment in the first degree. Now, however, I want to walk through the jury instructions to show you that we have met our burden of proving beyond a reasonable doubt that Devonen Briggs is in fact guilty of murder. So if you will, look at page 8, instruction 6, which is titled Self-Protection. The first thing I want to talk about under self-protection, if you'll look at the instructions, is number 1. What number 1 does under these instructions is it will address whether the defendant was entitled to self-protection at all, whether he was entitled to use self-protection. There's a lot of words in these jury instructions, so that's why I want to walk through them with you step by step. I'm going to do my best to help you understand what they're saying. But for this self-protection one, if there's one thing I do want you to keep in mind, it's this. Force must be met with force. Whatever type of force is being used against you is the force that you can return. That is the self-defense. That is self-defense.
Objection, Your Honor. May we approach, please?
You may.
I don't want to interrupt their defense because I know, they're closed, because I know it is closing argument, but I would simply object to any interpretation of what the law is that's being offered by the Commonwealth. First of all, that's not the standard for self-protection, and I would caution that the jury's going to have to rely on the court's instructions as to what the law is and how it applies in the context of self-protection, Your Honor. If they want to go through and they want to apply the facts to the law, that's fine. But now they're trying to define what the law is, respectfully, Your Honor. And that's, I think it's evading the profits of the court, Your Honor.
Well, what she said was, number 1, legally accurate, and number 2, that Mr. Eggers spent a good portion of his defense, probably objectionably, trying to define wantonly and recklessly in ways different than the instructions you're going to give him. So she said you can meet the force with the force you have. That's the whole self-defense statute.
I'll allow it, and Mr. Eggert did make similar arguments, so I'll overrule the objection.
Like I was saying, if there's one thing I want you to keep in mind, it's that force is to be met with force. Force can be met with force. Throughout this entire trial, defense counsel has made countless attempts to convince you that Devonen Briggs believed he needed to pull out his gun to protect himself from imminent death or serious physical injury. To determine if Devonen Briggs was in fact entitled to use self-protection, we can look at the amount of force he actually used in this case. Devonen Briggs used deadly force. He pulled out a gun and he shot and killed Jose Munoz. Deadly force. The instruction tells us that the only time, and this is, I'm sorry, we're still under instruction number 6, tells us that the only time someone is entitled to use deadly force is if they believe deadly force is necessary to protect themselves from death or serious physical injury. Devonen Briggs didn't believe Jose Munoz was about to kill him. He didn't believe Jose Munoz was about to cause him serious physical injury. How do we know this? You heard testimony about how Jose barely spoke English. Again, not enough English to formulate any verbal threats. He never said a word to him. You heard testimony about how, from the defendant himself in the interview with Detective Christman, Devonen Briggs himself says he pulls the gun out of his waistband, racks a bullet into the chamber, and then he sees an arm going back. Doesn't it make sense when you think about that, and when you think about the sequence of events and you use your common sense? Doesn't it make sense that then Jose watched Devonen Briggs pull a gun and only brought his fist up in an attempt to defend himself? You heard Devonen Briggs tell Detective Christman that Jose was the only person in front of him when he pulled the trigger. Defense counsel has asserted that Devonen Briggs believed he was going to be mauled or that he was being attacked by Jose and his family. However, none of the facts say that. None of the evidence you've heard says that. All it says is Jose and Devonen Briggs are standing toe-to-toe. It does not say that Jose and all of these children that he was with and his fiance and the sister-in-law and the brother-in-law were attacking him. It doesn't say. You have not heard any evidence about that. Almost as important as what you did hear in this case pertaining to the defendant alleging that he needed to protect himself is what you didn't hear. You never heard testimony from anyone, including the defendant in his interview with Detective Christman, say that he was scared for his life. You never heard him tell police he thought Jose had a weapon. You never heard him say he believed Jose was going to kill him. This is where I would ask you to use your common sense. Again, going back to jury selection when we talked about why do people lie? Why would you assert self-defense? Why would you say I was defending myself? Because you don't want to go to jail. Because you don't want to answer to whatever consequences stem from your actions. You even heard yourself in the defendant's statement in his interview with Detective Christman that Devonen Briggs' wife looked at him after he shot Jose Munoz and said, "Why did you do that? Why did you do that?" I don't think that she would ask that question if she knew the answer. And I think that if she knew the answer, it would be obvious because he was protecting himself. I think she asked that because there was no reason for it to happen. Devonen Briggs did not face any threat of death that night. Instead, he was the threat. If anything, Jose Munoz had the legal ability to protect himself as soon as Devonen Briggs pulled that gun. I'm going to ask that you all find that Devonen Briggs is not entitled to self-defense under instruction number 6. The first part of that is what we just discussed. We can look at the second part now. Basically, the second section is telling you that there is no duty to retreat. So here we don't have that issue. There was no duty to there's never a duty to retreat. That's our law in Kentucky. So, but that doesn't matter if he is not entitled to self-defense. So I'm asking you under instruction 6.1 to find that he did not believe that it was necessary to use deadly force to protect himself against death or serious physical injury at the hands of Jose Munoz. Ultimately, none of the evidence presented to you in this trial would lead you to believe that Devonen Briggs was entitled to self-protection that night. Therefore, if you agree that Devonen Briggs was not entitled to self-protection under instruction number 6, then you do not need to proceed to instruction number 7. Instruction number 7, if you want to flip to page 9, instruction number 7 are the exceptions. So we will go over these in just a minute, but you do not need to pay attention to these if you do not believe he was entitled to use self-defense under instruction 6. If you do believe he was entitled to use self-defense under instruction 6, instruction 7 is going to provide you with 2 times that he is not, like, self-defense assertion is totally off the table. You cannot claim self-defense in these 2 situations. So if you will look at page 9, instruction 7, subsection 1 is going to be addressing the initial aggressor. So the initial aggressor exception, under that exception, Devonen Briggs will not be entitled to self-protection if you find that he was the initial aggressor, which we are asking you to find. Here's how we know he was the initial aggressor. You heard testimony that he pushed a 4-year-old child. That's the first physical contact that was made in this whole situation. You heard testimony that he chest bumped the victim first. You heard testimony that he hit the victim first. You saw from the recreation of Detective Chrisman's interview with him that when she approached him to gauge the distance between him seated and how Jose Munoz had walked up to him, that the distance was so close that they were touching, and she had to take a step back so that when he stood up, he didn't touch her, he didn't hit her, he didn't chest bump her, he didn't push her, no physical contact was made. If she had not, then it's reasonable to believe that physical contact would have been made, which would have further corroborated witness testimony that you heard in this trial. You heard testimony and you've heard defense counsel's assertions that Jose shoved Devonen Briggs. He did. After the defendant chest bumped him, laid hands on a 4-year-old, threatened to smack the shit out of his wife, his fiance, and continued to attempt to start a course of conduct with his language, the way he was acting, and then claim self-defense when that conduct unfolded. As such, he is not entitled to self-protection, and this exception applies to him. The self-protection is not available to him under this initial aggressor exception. If after hearing the evidence of that, you do not believe that Devonen Briggs was the initial aggressor, then you can look at subsection 2 on the same page. Basically, what subsection 2 is another exception called provocation. So the Commonwealth, again, believes that we have provided you with evidence beyond a reasonable doubt that Devonen Briggs provoked Jose Munoz to use or attempt to use physical force upon him, and that he did so with the intention of causing death or serious physical injury to Jose Munoz. You heard testimony that Devonen Briggs, again, pushed a 4-year-old. You heard testimony that Devonen Briggs was making racial comments to Jose and his family. You heard testimony that even after a manager came out, things cooled down, maybe started back up again. Jose was the one that calmed them down the second time. So he's the one that cooled things off. But Devonen Briggs couldn't help himself. He just continued to instigate. He continued to say things to Jose and his family under his breath. We have witness testimony that has spoken directly to that. They heard it. Stephen Bell testified that he heard the defendant say to Linda, I don't care if you're a woman, I'm going to smack the shit out of you. Devonen Briggs had a loaded gun in his waistband. He knew that provoking and instigating Jose and his family in this way with the racial comments, with the I'm going to slap the shit out of you, I don't care if you're a female, all of those type of comments, he knew would elicit a reaction from Jose. And in turn giving Devonen Briggs a reason to shoot and kill him. If you believe that Devonen Briggs provoked Jose Munoz to use physical force upon him, and he did so with the intent of causing death or serious physical injury against him, then again, Devonen Briggs is not entitled to self-protection under this instruction. In other words, if you believe Devonen Briggs provoked Jose Munoz to use physical force upon him, self-defense is off the table. It's, again, the same sort of thing as the initial aggressor. You can't create a problem, and then once the problem comes to fruition, you can't say, oh, well, I'm claiming self-defense, because you started it. So if you have made it this far in the instructions, that was instruction 7, and believe that Devonen Briggs was entitled to self-protection under any of those previous theories, then what you will look at is what Devonen Briggs' belief was. We will get there. On the other hand, if you agree that Devonen Briggs was not entitled to self-protection under any of those previous theories, then you will proceed to instruction number 8, which is murder, page 10. I just want to walk through this with you really quickly. This is easy peasy. So under instruction 8, which is murder, you'll find the defendant, Devonen Briggs, is not guilty under this instruction unless you believe from the evidence beyond a reasonable doubt all of the following. Number 1, it's not disputed that the evidence that led us here took place on February 23rd, 2019 at the Olive Garden on Outer Loop. You can check that off. That has been proven. Further, you can check off that it's not disputed that Devonen Briggs killed Jose Munoz by shooting him. Not only is it just undisputed, but you also heard the medical examiner testify to the cause and manner of death, and you also heard Devonen Briggs himself in the interview with Detective Chrisman say, I shot him. That is not up for dispute, so we can also check that off. There's an and there. So what happens now is once you've checked all those initial things off, you're going to have to look at whether you believe that the murder was caused intentionally or wantonly. So basically there are 2 separate theories under this instruction, but it doesn't matter as long as everyone in the jury comes to a conclusion of either intentional or wanton, then that is still going to be unanimous for the purposes of murder. So again, yes, it's not just, none of that top stuff is disputed. Let's first talk about intentional murder. The Commonwealth does believe that we've presented evidence that shows beyond a reasonable doubt that Devonen Briggs intentionally shot and killed Jose Munoz. You heard evidence that the defendant made the conscious, deliberate choice to pull a gun from his waistband, turn off the safety, rack a bullet into the chamber, place the muzzle against Jose Munoz's chest, pull the trigger, and take his life in front of his small children. The defendant asserts that he shot him from down here. The reason that I know defense counsel is saying it doesn't matter, it does matter. It matters where he shot him because it shows what type of state he was in when the gun went off. If he shot from down here, okay, his story, the story that he's told police may make a little more sense until it doesn't, because the bullet entered here and exited here. So this is a downward trajectory, just like the medical examiner told you. And because of that, we know that the gun was positioned like this, within 2 inches, however close defense counsel said it was, very close proximity. For him to raise the gun and put it up to his chest in a threatening manner, That's intentional murder. That's not wanton murder. That's not manslaughter. That's not reckless. That is, he intended the result, which was to cause Jose Munoz's death. That's intentional murder. Okay. Okay. So we are asking you, well, let's move on to the wanton murder now. So that is intentional. Let's move on to wanton. So after considering all the evidence and the intentional murder, and if you don't believe Devonen Briggs intentionally shot and killed Jose Munoz, then we believe that the evidence will show that he wantonly shot and killed Jose Munoz. We believe that the evidence shows beyond a reasonable doubt that Devonen Briggs wantonly engaged in conduct, at a minimum, which created a grave risk of death to another and thereby caused the death of Jose Munoz under circumstances manifesting an extreme indifference to human life. This would be a situation, potentially, where he shot from down here. He might not have necessarily, it speaks less to intent and more to, I'm just going to fire the gun and see where it lands. When something is this close, you know where it's going. Okay. And then the final, so you have the intentional and the wanton, and then you also, so there's the and, number 3, you also have to find that he was not privileged to act in self-protection. So rewinding all the way back to the beginning, you will, in order to find murder, you have to find that he was not entitled to act in self-defense. Okay. So next in the instruction, let's turn to page 11 for the second-degree manslaughter. Give me 1 second. Okay. So second-degree manslaughter, the main difference between, so there's still a wanton element in second-degree manslaughter. The difference between the second-degree manslaughter wanton and the murder wanton is the amount of wantonness. And I know that makes perfect sense, totally clear. But basically you have a big wanton, which is the murder, and then you have a little wanton, which would be the man too. So it's the degree of wantonness in those that will determine which one you opt for. So the manslaughter 2, the wantonness basically is that what this boils down to is that his belief, so if you find, look at 3B, though otherwise privileged to act in self-protection, defendant was mistaken in his belief that it was necessary to use physical force against Jose Munoz in self-protection, or that his belief in the degree of force necessary to protect himself, and that when he killed Jose Munoz, he was aware of and consciously disregarded a substantial and unjustifiable risk, that he was mistaken in that belief. So what this means, we'll go back to the force being met with force, is that you thought that you were, your life was in danger, so that's why you pulled your gun, but you were mistaken in that thought. That's not true. So we are not asking you to find man 2, we are asking you to find murder. All of Devonen Briggs' actions were intentional. I just wanted you to know the difference between the two in case there was any confusion. So I will now ask you to turn the page and look at reckless homicide. Again, the only difference here is the mindset. So this would be in a reckless manner as opposed to a wanton manner, which is the manslaughter. So we are, again, not asking you to find reckless or return a verdict for reckless homicide. We are asking you to return a verdict for murder because Devonen Briggs was not mistaken in his belief. He did not fail to perceive the risk. He knew the risk. He was not mistaken in his belief. He knew he wasn't armed. He knew he wasn't coming at him to kill him. They were in an Olive Garden waiting room with all of their families. It's a family restaurant. There was nothing to show that he was going to hurt him in any way. So yes, we would ask you to find that Jose Munoz was shot intentionally by Devonen Briggs. So I'd like to do, okay, I'm going to try to do this in the air. We'll see how it works. So basically you have the big theory, which is, did the defendant believe, do we agree that the defendant believed that he needed to use deadly force in order to protect himself from death or serious physical injury? If your answer to that is yes, so that means if your answer to that is yes, then you will go to okay, if your answer to that is yes, then you will go look at whether or not his belief was mistaken. If his belief was mistaken, you're going to look at how mistaken was it. If it's a wanton level, then you go to man 2, and that will be your verdict. If it's a reckless level, then it will be reckless homicide. We'll go back up to was he mistaken in his belief? No. And he's not guilty because he was justified under the law. What we will ask you to find, and what we believe that we have proven beyond a reasonable doubt, is that the defendant was not. We do not agree that the defendant believed deadly force was necessary to protect himself from death or serious physical injury. No, if your answer is no to that, there's no self-defense and he's guilty of murder. And that's what we ask you to find. Next, let's talk about wantons, the wanton endangerments. We can flip to, so there are, I know that Mr. Everett already went over this and so did Judge Clay, but there are wantons for Linda Flores, Perla Flores, Jose Rodriguez. They're the 2 children that belong to Perla and the 2 children that belong to Linda. So that is 7. So there are 7 counts of wanton endangerment. Defense counsel asked you to find wanton endangerment in the 2nd degree. The difference between 1st degree and 2nd degree wanton endangerment is the risk, is the
may we approach
danger. Okay.
Just very quickly, the defense did not ask the jury to find that wanton second. I just want to make it clear, we asked for not guilty across the board. She just made it sound like we asked for them to come back on wanton second. I just want to be clear.
Okay, I'm sorry. I can fix that. Okay. Yeah.
Okay, so defense counsel is not asking you to find 2nd degree wanton endangerment, they're asking you to find nothing. Just wanted to clarify that. Okay, let's go back to the wanton endangerment, the difference between wanton first and wanton second. So under wanton first, it is that by discharging his firearm, he created a substantial risk, a substantial danger of death or serious physical injury to those 7 individuals. Under 2nd degree wanton endangerment, it's that by firing by discharging his firearm, he wantonly created a substantial danger of physical injury to those people. So the difference is the injury. There's a danger of death under first degree, which I think that we have proven beyond a reasonable doubt. For all 7, the bullet went through Jose Munoz's body. It exited the other side. Could have hit, it was traveling at a very high rate of speed, and it could have hit someone else. So there was a danger of death to potentially any of the people in the lobby, but the people who were in the closest proximity would have been Jose's family, which would have been the 4 small children and the 3 adults minus Jose. So there's 3 adults, so there's 7. So we would ask you to find that Devonen Briggs is guilty under all 7 counts of wanton endangerment in the first degree. And let me make sure I cover all this for you all. Okay. Yes. Okay. After walking through jury instructions, on behalf of the Commonwealth, I'm going to ask you to return a guilty verdict for murder, whether that be under the wanton theory or the intentional theory. And I'm also going to ask you to return a guilty verdict on all 7 counts of wanton endangerment in the first degree. Thank you. That's all, Your Honor.
Thank you, Ms. Profumo. All right, ladies and gentlemen, I will at this time draw 2 alternate jurors. As we discussed in voir dire, we have sat 14 of you, but only 12 will be going back to deliberate. So at this time, if I call your number, when the jury panel goes back with the sheriff to deliberate, if the 2 of you could remain seated. Juror number 8863. And juror number 8780. If the 2 of you could remain seated. The rest of you will go back with my deputy sheriff, who I will place under oath. Do you swear that you will keep the jurors together and allow no person to speak to or communicate with them on any subject connected with the trial, and that you will not do so yourself?
Yes, I do.
Thank you. All right, everyone, you may proceed, or well, I'll ask you to proceed back with my deputy sheriff, except for the 2 of you who are alternates.
Except for the 2 that you read the name off for alternates, just remain seated, okay?
Should we all rise? Guess we all did out of that.
And then could the 2 of you approach? I'm going to take us off the record. Ms. Profumo?
No.
Or no? Okay. Did you all get my text message? I
Did
texted
it just
both of
come
you.
through?
I don't know if either of you checked your phones. I don't even know if I still have the correct number for you, Mr. Baker, but.
I checked it before I left. He has my number. So I'll go check.
Okay. Well, it doesn't matter right now.
Doesn't matter.
So we've got a question from the jury. Judge, is wanton endangerment first or wanton endangerment second still felonies? That's the question.
You can't answer the question.
So I think just tell them you are to decide the case based on the instructions you've been given?
Actually, the
Or
instructions
just
are,
the instructions are all you need? What would you?
yeah, that was by,
Mr. Egger
Um,
or Mr. McKee?
just, How about this? I cannot instruct you from, well, what were you going to say, Judge?
I just said you have been, you are to decide the case based on the instructions you've been given, or you have been given all of the instructions you need, or?
You've been given all the instructions, yeah.
is that what you want, Tom? What do you really want?
Okay.
I might agree.
I'm gonna say you have been given all of the instructions you
That's
need.
fine.
I mean, I think actually. But you asked for it, right?
Yeah.
So it's not, so it's not.
Thank you.
I was waiting outside for you.
Oh, ladies and gentlemen, I do want to say, before we bring the jury in and read the verdict, in the same way that I said during trial, there are to be no emotional outbursts when the verdict is read, okay? I want to be clear. If you are unhappy or happy with the verdict, whatever your response should be silent, okay? If you do not feel that you can contain yourself, you need to leave the courtroom before the verdict is read.
Back, Judge. Go. That's so.
All right. All rise for the jury. All jurors present, Your Honor.
Thank you. Please be seated, everyone. Has the jury been able to reach a verdict in this case?
Yes.
All right, who is the foreperson? Sir, could you please hand the jury forms to my sheriff? Thank you. Okay, would you like to read the verdict, or would you like me to? Okay. Verdict form number 1, murder. We, the jury, find Devonen Briggs not guilty of murder as set out in instruction number 8, signed by the foreperson. Verdict form number 2, second-degree manslaughter. We, the jury, find Devonen Briggs not guilty of second-degree manslaughter as set out in instruction number 9, signed by the foreperson. Verdict form number 3, reckless homicide. We, the jury, find Devonen Briggs not guilty of reckless homicide as set out in instruction number 10, signed by the foreperson. Verdict form number 4, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 11, signed by the foreperson. Verdict form number 5, second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 12. Verdict form number 6, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 13. Verdict form number 7, second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 14, signed by the foreperson. Verdict form number 8, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 15. Verdict form number 9, second-degree wanton, signed by the foreperson. Second-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of second-degree wanton endangerment as set out in instruction number 16, signed by the foreperson. Verdict form number 10, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 17, signed by the foreperson. Verdict form number 11, second-degree wanton endangerment. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 18, signed by the foreperson. Verdict form number 12, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 19, signed by the foreperson. Verdict form number 13, second-degree wanton endangerment. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 20, signed by the foreperson. Verdict form number 14, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 21, signed by the foreperson. Verdict form number 15, second-degree wanton endangerment. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 22, signed by the foreperson. Verdict form number 16, first-degree wanton endangerment. We, the jury, find Devonen Briggs not guilty of first-degree wanton endangerment as set out in instruction number 23, signed by the foreperson. Verdict form number 17, second-degree wanton endangerment. We, the jury, find Devonen Briggs guilty of second-degree wanton endangerment as set out in instruction number 24, signed by the foreperson. Does any counsel wish to poll the jury?
No, Your Honor.
No,
All right. Okay, thank you all. I'm going to ask you to return to the back with my sheriff. We will reconvene here shortly. All right? Thank you all.
All rise for the jury.
Oh, that's good. I don't think I have a jury verdict form for that. I'll look back.
Okay. Just in case we're broadcasting to the back. Counsel, could you please approach?
Of course.
I mean, I assume we're not having honestly, I don't know how that works if we have a sentencing phase, but I mean, he's already served out.
He has.
Do you all, is it just let the jury go? Or is
Yeah,
there
I mean, I
any
think-
agreement on a sentence, or what do you all want to do?
I guess you'd have to get that, but given the fact that he actually has served more than 12 months, you can just start him out from the bench. And that's fine with me. What did,
I think it's 4 counts.
I didn't know we
Four
wanted
counts.
anything until the end
I
there.
think
I
that's,
misheard.
it's all the children, I think.
Okay. Then it can't run consecutive.
No, it's got to run concurrent.
Right.
So if the judge did 12 months serve out, he's.
12 months, credit 12 months, see you later.
Okay,
Just,
starting with number 18. Let me make sure, but yeah, I think it's all the
I
children.
would ask this, because in this new era where they walk around with you, that when you finish, that let me get my half out, or vice versa, that this weird where they're walking around with us and everything, it's.
What do you mean walking around?
One side first and then the
Yeah,
other
where the
side.
defendant's
I
standing
agree.
behind
I
me
agree.
and
I agree.
everything, and they're mad, and then the families are
I
kind of
agree.
mad, that you go ahead, well, I'm gonna excuse you guys first, get on the fucking elevator and get out of here.
It might not be a bad idea to have the sheriffs with each side.
Okay.
But I'm gonna sentence him now?
Yeah.
Okay,
Yeah.
all right. Okay.
Okay. You could fine him too if you want to.
Hmm?
You could fine him if you want to.
Well, I think. All right, in light of the jury's verdict, which is all four, I believe it's 4 Class A misdemeanors, for which the maximum penalty is 365 days in the county jail. And Mr. Briggs, you have served at least that much on home incarceration, and you are required to be credited for that time. I will sentence you to credit time served. That'll be a 12-month sentence, credit time served. So you will be served out today, and you should be released today from home incarceration. All right, is there anything we need to address on the record? I'm going to let each side go out separately. So if the Commonwealth and your the families
Victim's family.
could leave first, and then
right.
the defense
Thank
can
you. If you
exit
give us a minute.
in a few minutes. All right, thank you all. I go off.